Welcome to Shenkman Education. My name is Marty Shenkman. This is a really interesting topic that I haven't seen written about, talked about anywhere. And for some group of folks out there, this could be really important. So you have a couple that are married. Marriage is getting a little shaky. One spouse says, let's do an estate plan. First of all, there's all sorts of fascinating issues, especially lawyers need to be aware of them, but everyone really needs to be both consumers and the professional advisors about who can represent who and what happens when you're married going for advice. You need to be very careful when you're doing an estate plan as a couple to make sure that it works for both of you and what happens in the event of the marriage not working out. Be careful that the often quoted 50% divorce rate is really misleading, because it's like, if the average American family has 2.3 kids, you've never seen a third of a kid, have you? So the divorce statistics are very broad, and you may have a better assessment of the risk of divorce for you. But make sure you do think about it and talk about it. So here's the concept. I'm going to make the husband the bad guy just because it's easier to use husband and wife and make the example simple. And by the way, a lot of the historic cases, court cases where this has occurred, it's always the husband that's been the bad guy. So don't be upset. So husband takes wife, they go to a estate planner, and husband has lots of assets transferred from wife into a trust for himself. Yes, that may save estate tax, it's asset protection in case the couple gets sued, and so on and so forth. Oh, now, gee, unexpected? Not really. A year later, 6 months later, maybe 2 years later, not so long after it was planned, probably, husband and wife get divorced. And now husband says, oh my, ex-wife, you can't get access to any of the assets in this trust because it's irrevocable. Irrevocable kind of means it can't be changed, but there's lots of other video clips explaining decanting and non-judicial settlement agreements and other ways you can change an irrevocable trust, which is an interesting thought to keep in mind too, how irrevocable is irrevocable. But the argument is it's an irrevocable trust. Wife funded it with millions of dollars or whatever is appropriate for you. It could be hundreds of millions, it could be whatever, with appropriate planning. And now she can't access these assets. You need to evaluate that from a number of different perspectives. There was recent cases in New York and Connecticut, for example, where these trust planning structures were pierced and disregarded in the context of pre-divorce planning, like I said. And there's video clips on those. But here's another concept. Is that funding of the trust analogous to, equivalent to, almost the same as a post-nuptial agreement? Many states have restrictions and laws governing post-nuptial agreement. A post-nup, or abbreviated post-nup, is a mid-marriage agreement. So in other words, you're already married and you're going to sign a written agreement that affects what happens to assets if there's ever a later divorce. It's not uncommon at all. The law will generally, and it's different by state, so you have to talk to a matrimonial attorney in your state. Both spouses are represented by independent attorneys. There has to be some fairness to it. Fairness is required, I would think universally, but I obviously can't check every state's law, because as a spouse, you have a fiduciary or position of trust vis-a-vis your other spouse. The husband to the wife and wife to the husband. So there's criteria. Does this trust plan meet that criteria? Here's a concept. That trust plan that was created mid-marriage when the marriage was already faltering may be really no different than a post-nuptial agreement. It's called a trust, but it's a post-nuptial agreement in effect. And that may give you an avenue to challenge what if this happened to you, for example. How so? The challenge is based on, Your Honor, my husband called this a trust. I didn't have an independent attorney. I used his attorney. It was completely unfair to me. I put assets in a trust. He can get access to them. I can't. Or maybe the kids get access, but I'm cut out. So it was completely unfair. There was no consideration, is the legal term, or quid pro quo, economic benefit to me. It was completely unfair to me. Why is that any different than a post-nuptial agreement? This arrangement, if you simply change the title from trust to post-nup, would not pass muster under state law. So this is a complex concept. It's a new concept. I haven't seen it written about or talked about anywhere. If you're going through a divorce and you can't access assets in a trust that your spouse was involved in creating, discuss this concept with your matrimonial attorney. I hope this was informative and an idea that may help. Please keep in mind that all of the video clips and all the information in this clip are for educational purposes only. Do not take any legal or other action without appropriate professional guidance. Don't you love legal disclaimers? Thank you for joining me. For more information, see shenkmaneducation.com. shenkmaneducation.com. Thank you.